I'd like to thank the committee for this invitation to testify. I also regret not being able to attend at Strasbourg directly. I wasn't able to attend due to travel. Before I begin the prepared remarks, I have to open with a short disclaimer. With the greatest respect, I reserve the right to decline any question for which providing an answer would prove contrary to the public interest or to the national security of any state. I caution that if some of my comments appear more general than one might expect, given my technical expertise and direct personal experience with many of these programs, I apologize in advance for the lack of precision and ask that you bear in mind that particular general answers may be the product of principle or circumstance rather than a lack of specific knowledge. I'm proud of the fact that despite the dramatic protestations of intelligence chiefs, no evidence has ever been shown by any government that the revelations of the last year have caused any specific harm. And the guiding principle of my participation in today's testimony is to ensure this unbroken record of serving the public interest while minimizing any potential harms continues without interruption. I also note that any facts raised in these testimony have been independently determined by journalists to serve a vital public interest. Beyond that, I remind the committee that even where there exists a compelling public interest for making a particular disclosure, I may not be able to provide additional detail. Due to failures in whistleblowing legislation in the United States, there are no legal channels available for individuals such as myself, who are employed as private contractors rather than direct federal employees, to safely testify in front of legislative committees. As such, I ask for your understanding in recognizing that despite the executive policy changes, legal reforms, and court decisions to improve the rights of others that have occurred as a result of my disclosures, I remain in a position of significant legal jeopardy. I believe last year showed that an expectation of persecution for political speech in the context of national security whistleblowing is not unreasonable. And though it goes without saying that at this point, I would like to clarify that I have no intention of harming the United States government or straining bilateral ties between any nations. My motivation is to improve government, not to bring it down. I'd like to request that my previous testimony to the EU Parliament be entered into the record so that rather than exhaustively covering previous statements, we can use this time instead to discuss programs less well understood by the public or perhaps that have been misinterpreted by journalists, as well as to address a few novel questions of particular significance that I received from this committee. To briefly summarize my testimony before EU Parliament, it is points we will likely touch on today, beginning and going forward from here. That the US government confirmed in at least 3 independent determinations within the last 6 months that the kind of dragnet mass surveillance we discussed today is ineffective for preventing terrorism. The government also asserted at least twice that such programs appear to have no basis in law. That Western involvement in mass surveillance set a dangerous precedent, encouraging and potentially legitimizing the activities of authoritarian governments that desire to construct similar systems.
Mr. Snowden, could I just ask you to slow down as the video link is a little difficult here and our interpreters are having some difficulties. So if you could just speak more slowly, I would appreciate it.
Absolutely. I have too much in my statement. Repeat that or continue from here?
If you could continue from here, but just more slowly. Thank you.
Thank you. The U.S. National Security Agency has a directorate that has worked to intentionally subvert the privacy laws and constitutional protections of EU member states against mass surveillance. That the body of public evidence indicates mass surveillance results in societies that are not only less liberal, but less safe. That the NSA shares mass surveillance technologies with some EU member states, as well as access to its own mass surveillance systems. That reports of intelligence agencies using mass surveillance capabilities to monitor peaceful groups unrelated to any terrorist threat or national security purpose, such as the United Nations Children's Fund, or spying on American lawyers negotiating trade deals are in fact accurate. That the secret court in the United States that oversees mass surveillance programs is best described as a rubber stamp court. Mass surveillance results in societies that are not only less liberal, but less safe. That the NSA shares mass surveillance technologies with some EU member states, as well as access to its own mass surveillance systems. That reports of intelligence agencies using mass surveillance capabilities to monitor peaceful groups unrelated to any terrorist threat or national security purpose, such as the United Nations Children's Fund, or spying on American lawyers negotiating trade deals, are in fact accurate. That the secret court in the United States that oversees mass surveillance programs is best described as a rubber stamp court. This court has rejected only 11 out of approximately 34,000 requests made by the government over a period of 33 years. It hears arguments only from the government, and its judges are appointed by a single individual without the benefit of any outside confirmation or review. I add that this secret court was only intended to issue individual and routine warrants for surveillance, not to decide legal issues of global importance or to authorize general untargeted warrants for instance, the clandestine wiretapping of anyone in Germany, as was recently revealed. The UK Electronic Surveillance Service, GCHQ, collected on a massive scale images from web cameras, often within bedrooms in private homes, without any individualized suspicion of wrongdoing. This activity continued even after GCHQ became aware that the vast majority had no intelligence value at all, and roughly 10% of all images upon auditing were discovered to be intensely private, depicting some form of nudity or other private intimacy. That the NSA had intentionally sought to collect similarly explicit sexual material regarding religious conservatives whose political views it disfavored and considered radical, for the purpose of exposing it to damage their reputations and discredit them within their communities. This is an unprecedented form of political interference that I don't believe has been seen elsewhere in Western governments. That no legal means currently exist to challenge such activities or to seek remedies for such abuses. That mass surveillance is used by the NSA, as well as partners and adversaries, for the purposes of economic espionage. NSA had unlawfully compromised the world's major financial transaction facilitators, to include SWIFT and Visa. And in their reports, they explicitly noted that such information provided, quote, rich personal information, unquote, including data that, quote, is not about our targets, unquote. The governments caught engaging in mass surveillance have in the last months have stopped attempting to justify the programs as being related to national security, and have instead shifted to a far looser restriction of valid foreign intelligence purposes. This is particularly problematic for human rights, because any government can justify almost any privacy violation on that basis. And it reflects some governments are willing today to cede a hard-won moral high ground rather than implement surveillance reforms. That I believe the international community should agree to new common standards of behavior, perhaps a convention on the prevention of mass surveillance, as well as the adoption of common technical standards mandating the use of secure by default communication protocols for the transmission of data, if they are to have any hope of protecting citizens' communications against unlawful surveillance. That strong, pervasive encryption provides a robust defense against mass surveillance but does not preclude governments from gaining access to the communications of specifically targeted individuals for the purposes of lawfully justified investigations. Now, I'd like to move on to the questions provided by the committee, my responses to them. The question was, to your knowledge, does the NSA or GCHQ or other signals intelligence services engage in sophisticated data mining analyses of the data captured by the programs that I have exposed? Do they use sophisticated algorithms of the kind widely used in commercial data mining to seek out further people of interest? To answer yes. Algorithms are used to determine unknown persons of interests who are not actually suspected of any wrongdoing. This question is a good example of something that journalists and previous inquiries working independently from public documents, newly public documents, have had trouble properly interpreting. Some reporting on this issue has already occurred, but due to my inability to participate in the reporting at that time, these groups were unable to achieve a complete understanding of the full meaning of these documents. For example, it has been reported that the NSA's X-key score framework for interacting with the raw signals intercepted by mass surveillance programs allow for the creation of something that is called fingerprints. I'd like to explain what that really means. The answer will be somewhat technical for a parliamentary setting, but these fingerprints can be used to construct a kind of unique signature for any individual or group's communications, which are often comprised of a collection of, quote, selectors, such as email addresses, phone numbers, or usernames. This allows state security bureaus to instantly identify the movements and activities of you, your computers, or other devices, your personal internet accounts, or even keywords or other uncommon strings that indicate an individual or group out of all the communications they intercept in the world are associated with that particular communication. Much like a fingerprint that you would leave on the handle of your door or your steering wheel for your car and so on. However, though that has been reported, that is the smallest part of the NSA's fingerprinting capability. You must first understand that any kind of internet traffic that passes before these mass surveillance sensors can be analyzed in a protocol agnostic manner, metadata and content both. And it can be today, right now, searched not only with very little effort via a complex regular expression, which is a type of shorthand programming, but also via any algorithm an analyst can implement in popular high-level programming languages. This is very common for technicians. It's not a significant workload. It's quite easy. This provides a capability for analysts to do things like associate unique identifiers assigned to untargeted individuals via unencrypted commercial advertising networks through cookies or other trackers of common tracking means used for businesses every day on the internet. With personal details, such as an individual's precise identity, personal identity, their geographic location, their political affiliations, their place of work, their computer operating system and other technical details, their sexual orientation, their personal interests, and so on and so forth. There are very few practical limitations to the kind of analysis that can be technically performed in this manner, short of the actual imagination of the analysts themselves. And this kind of complex analysis is in fact performed today using these systems. I can say with authority that the US government's claims that, quote, keyword filters, searches, or, quote, about analysis have not been performed by its intelligence agencies are in fact false. I know this because I have personally executed such searches with the explicit authorization of US government officials. And I can personally attest that these kind of searches may scrutinize the communications of both American and European Union citizens without the involvement of any judicial warrants or other prior legal review. What this means in non-technical terms, more generally, is that I, an analyst working at NSA, or more concerningly, an analyst working for a more authoritarian government elsewhere, can, without the issue of any warrant, create an algorithm that for any given time period, with or without human involvement, sets aside the communications of not only targeted individuals, but even a class of individual, and that just indications of an activity, or even just indications of an activity that I, as the analyst, don't approve of, something that I consider to be nefarious, or to indicate nefarious thought, sort of pre-criminal activity, even if there's no evidence or indication that that's in fact what's happening and that it's not an innocent behavior. The nature of the mass surveillance, of these mass surveillance technologies, create a de facto policy of assigning guilt by association, rather than on the basis of specific investigations based on reasonable suspicion of wrongdoing. Specifically, mass surveillance systems like X-Keyscore provide organizations such as the NSA with the technical ability to trivially track entire populations of individuals who share any trait that is discoverable from unencrypted communications. For example, these include religious beliefs, political affiliations, sexual orientations, contact with a disfavored individual or group, history of donating to specific or general causes, interactions or transactions with certain private businesses, or even private gun ownership. It is a trivial task, for example, to generate lists of home addresses for people matching the targeted criteria, or to collect their phone numbers, to discover their friends, or even to analyze the nature and proximity of their social connections by automating the detection of factors such as who they share pictures of their children with, which is capable of machine analysis. I would hope that this goes without saying, but let me be clear that the NSA is not engaged in any sort of nightmare scenarios, such as actively compiling lists of homosexual individuals to round them up and send them into camps or anything of that sort. However, they still deeply implicate our human rights. We have to recognize that the infrastructure for such activities has been built and is in reach of not just the United States and its allies, but any country today. And that includes even private organizations that are not associated with governments. Accordingly, we have an obligation to develop international standards to protect against the routine and substantial abuse of this technology, abuses that are ongoing today. I urge the committee in the strongest terms to bear in mind that this is not just a problem for the United States or the European Union, but that this is in fact a global problem, not an isolated issue of Europe versus the Five Eyes or any other country. These technical capabilities don't merely exist, they are already in place and actively being used without the issue of any judicial warrant. I state that these capabilities are not yet being used to create lists of all the Christians in Egypt, but let's talk about what they are used for, at least in a general sense, based on actual real-world cases that I can assert are in fact true. Fingerprints, for example, the kind used in X-Keyscore, have been used, I have specific knowledge that they have been used, to track and intercept, and monitor the travels of innocent citizens who are not suspected of anything worse than booking a flight. This was done in Europe against EU citizens, but it is of course not limited to that geographic region, nor that population. Fingerprints have also been used to monitor untold masses of people whose communications transit the entire country of Switzerland over specific routes. They're used to identify people. Fingerprints are used to identify people who have had the bad luck to follow the wrong link on an internet site, on an internet forum, or even to download the wrong file. They've been used to identify people who simply visit an internet sex forum. They've also been used to monitor French citizens who have never done anything wrong other than logging on to a network that's suspected of activity that's associated with a behavior that the National Security Agency does not approve of. This mass surveillance network constructed by the NSA, which I point out is an agency of the US Military Department of Defense, not a civilian agency, and is also enabled by agreements with countries such as the United Kingdom, Australia, and even Germany, is not restricted to being used strictly for national security purposes, for the prevention of terrorism, or even for foreign intelligence more broadly. X-Keyscore is today secretly being used for law enforcement purposes, for the detection of even non-violent offenses, and that this practice has never been declared to any defendant or to any open court. This mass surveillance network constructed by the NSA, which I point out is an agency of the US Military Department of Defense, not a civilian agency, and is also enabled by agreements with countries such as the United Kingdom, Australia, and even Germany, is not restricted to being used strictly for national security purposes, for the prevention of terrorism, or even for foreign intelligence more broadly. X-Keyscore is today secretly being used for law enforcement purposes, for the detection of even non-violent offenses, and that this practice has never been declared to any defendant or to any open court. We need to be clear with our language. These practices are abusive. This is clearly a disproportionate use of an extraordinarily invasive authority, an extraordinarily invasive means of investigation, taken against entire populations rather than the traditional investigative standard of using the least intrusive means for investigating specifically named targets, individuals, or groups. The screening of trillions, and I mean that literally, trillions, of private communications for the vaguest indications of association or some other nebulous pre-criminal activity is a violation of the human right to be free from unwarranted interference, to be secure in our communications and our private affairs, and it must be addressed. These activities, routine, I would point out unexceptional activities that happen every day, are only a tiny portion of what the Five Eyes are secretly doing behind closed doors without the review, consent, or approval of any public body. This technology represents the most significant, what I would consider the most significant new threat to civil rights in modern times. The committee should consider what truly bad actors will use these same capabilities for if we allow them to go unchecked, and how we will develop enduring norms and technical standards to safeguard against such abuses wherever they occur. The next question is, to my knowledge, have the NSA or GCHQ used these surveillance powers and similar capabilities to spy upon highly sensitive and confidential communications of major human rights organizations, such as but not limited to Amnesty International and Human Rights Watch, and or smaller global, regional, or national non-government organizations? The answer is, without question, yes, absolutely they do. The NSA has, in fact, specifically targeted the communications of either leaders or staff members in a number of purely civil or human rights organizations of the kind described in the question, including domestically within the borders of the United States. Another matter of similar concern is the practice of what the US Drug Enforcement Agency now calls, quote, parallel construction. This is a technique whereby secret intelligence information is unlawfully used for law enforcement purposes. It is then concealed from courts, to include the courts of our European partners, depriving the accused of their right to challenge the legality of the initial surveillance. I will add that the initial intelligence information in such cases has often been gathered without the issue of any judicial warrant, as previously noted. This unlawful use of such secret evidence, whose existence or provenance has been concealed from both the defendant and the court itself, represents a serious threat to both the right to a fair trial and the right to face one's accusers. Given the growing global awareness of these intelligence practices, which we should recall have been declared by the United States government itself to have no statutory basis in law, I would encourage the committee to take immediate steps to address these concerns. The failure of a state to ensure binding assurances that intelligence information received from or provided to any foreign partner may not be used in such manners that could make them party to human rights violations carried out by trusted partners. To continue, I'd like to point out what I consider to be the likely response to any political inaction by elected representatives on these issues, and what I consider the future trends on encryption, the likely response to inaction, and the impact that they'll have for civil society. If a political solution to the problem of mass surveillance is not reached on an immediate basis, technical solutions are likely to be imposed by the international research and engineering communities. Should governments wish to retain the capability to easily monitor internet communications, they must act with immediacy to address the problem of mass surveillance. It is critical that policymakers recognize that the laws of parliaments are necessarily subordinate to the physical laws of the universe itself, and if issues of liberty and human rights in the digital sphere are left to technologists to address rather than elected bodies, governments are very likely to irrevocably lose some portion of their authority to interfere with the communications of legitimate targets. To illustrate, I want to state with respect, I'd like to correct the record on a point in the committee's introductory memorandum regarding the strength of encryption used today. Contrary to a point asserted in that memo, there are in fact today encryption schemes that are not susceptible to any realistic brute force attacks on any time scale. And I can confirm that this remains true even at the forefront of the classified state of the art. Properly implemented modern encryption algorithms, backed by truly random keys of significant length, can require the application of more energy to cryptanalyze, or basically to derive the solution to decrypt, than exists in the known universe. For example, if today we dedicated every supercomputer, every desktop computer, every smartphone on the planet to brute forcing a single 256-bit key space of this type, our sun, the sun in our solar system, will literally stop burning, and we'll be sitting around in the dark before we actually solve the problem and have enumerated all the possibilities within that mathematical space. To quote Bruce Schneier, who I'll point out is one of the world's foremost cryptographers, who actually wrote the book on applied cryptography, quote, "We cannot even imagine a world where a 256-bit brute force search is possible. It requires some fundamental breakthroughs in our physics and our understanding of the universe," end quote. The 256-bit keys that he discusses are incredibly common today. Anyone in this room can learn how to encrypt everything on their computer, on their hard drive, with this sort of functionally unbreakable code in the academic sense of the word, within the space of a single weekend. Not even no intelligence agency anywhere in the world working for even 10 years nonstop on this single problem, can break such codes. However, law enforcement agencies need not despair and be concerned that this will stop their work, as there are many other well-known ways around even such perfect, in a theoretical sense, encryption. Weaknesses in the specific implementation of encryptions in such encryption programs and libraries are common. In fact, we just saw one today that could affect 2/3 of all traffic on the internet. Beyond that, there are also methods around even robust encryption programs that have no known direct vulnerabilities. These methods, called, quote, side channel attacks, end quote, can allow actors such as government agencies, police bodies, and so on to steal the keys necessary to decrypt certain communications and complete their investigation without actually having to decrypt those communications by confronting the mathematical strength of the algorithms themselves. These techniques can be analogized to investigators installing a hidden camera to record a suspect dialing the correct combination to his or her safe where they hide documents or evidence or what have you, rather than having the government actually crack the safe with drills and saws or the sheer guesswork of trying to dial every potential combination. This distinction is of critical policy importance because it is these kind of side channel attacks that can only be applied successfully on a targeted, individualized basis. But if the same techniques are used in the technical context of untargeted mass surveillance that's not premised on specific individuals, specific targets, and justified investigations, these attacks can be rapidly detected, remediated, and protected against by the community of security researchers in the academic community worldwide. In the event that the political institutions of the international community fail to address today's surveillance abuses, this scenario, that of pervasive encryption that has to be countered by investigators through the case-to-case application of side channel attacks, is, I believe, the most likely response of the technical, academic, and business communities to the intelligence operations of today. I do not believe that this is necessarily something policymakers should be afraid or reluctant to support, as even with real comprehensive surveillance reforms, we cannot trust legal protections enshrined in the laws of the developed world to be respected and enforced elsewhere. That can only be achieved by enforcing those laws through common, interoperable technical standards that are backed by our international institutions. The most cost-effective means to guard against this kind of systemic violation of communication securities, the kind that we see in less liberal regions of the world today, seems to me to be pervasive encryption. In summary, the issues that we're facing today are complex. There are a number of unanswered legal questions that have to be answered not just by intelligence agencies who do have, I believe, necessary work, but by the public bodies and our elected representatives. It's very important to us that we as a society determine the appropriate balance between the desire of intelligence agencies to perform the most efficient work possible and to try new techniques that have never been proven and that now we see actually there's a growing body of evidence that they offer no real value, such as mass surveillance, and compare those against the traditional restrained means that we face. Personally, I believe that human rights are best protected and constitutional prohibitions should be placed against the use of mass surveillance and that favor the use of individual targeted surveillance. Individual targeted surveillance has been shown time after time, even in today's complex environment, even against specific hard targets, whether they're in North Korea, whether they're terrorists, whether they're sophisticated cyber actors or anyone else, to be effective. Our human rights can only be protected if we ensure that our laws have a clear meaning, and the meaning of the words within those laws cannot be secretly interpreted by any legal body or intelligence agency without the public's knowledge and consent. That's the end of my comments. Thank you.
Thank you very much, Mr. Snowden.